This isn't a private trust. This is a trust supervised by the probate court. Because Samantha is only 18 and the trust lasts until she's 40, that house is now stuck in the court system for 22 years. What if I told you that a simple estate plan designed to protect a family ended up doing the exact opposite? I'm going to tell you the story of a grandmother named Margaret. She wanted two things: to keep her estate simple and to protect her grandchildren from getting too much money too young. But because she relied on simple bank forms instead of a real plan, she accidentally handed an 18-year-old $1.1 million in cash overnight. And the one asset she did try to protect, her house, ended up trapped in a court-supervised nightmare for 22 years. But this story has a twist. The one person Margaret never trusted, her son-in-law David, actually got it right. I know because I was David's attorney. I built a plan that works. And then I had to step in to clean up the mess Margaret left behind. By the end of this video, you'll understand exactly why simple wills are often the most expensive mistakes you can make. Let's start with Margaret. She was a smart woman. She wasn't trying to be negligent. She was trying to be efficient. Like many people I meet in my office, Margaret believed that estate planning was just about who gets what. She thought, I don't need a fancy lawyer. I can just go to the bank and fill out forms. She had a specific fear: probate. She knew probate was expensive and public, so she used pay on death and transfer on death forms for everything she could. Her logic was, if I die, the money goes instantly to my kids. No court, no fees, simple. Probate attorneys don't benefit when people truly understand probate and try to avoid it. Probate attorneys profit when people use wills instead of trusts. If you weren't told the benefits of avoiding probate, then leave a comment and like and subscribe if you want more of this information explained in plain English. But she had a second fear: immature heirs. She knew that if something happened to one of her children, or both, she didn't want her grandchildren getting rich at age 18. So in her will, she added a safety clause. If any beneficiary is under age 40, their share must be held in trust and not distributed until age 40. Sounds like a good plan, right? Avoid probate with forms, protect the kids with the will. But she made one fatal assumption. She assumed the will and the forms would talk to each other. They don't. Now we have to get technical for a moment, because this one Latin phrase changes everything. Margaret's plan named her son Robert and her daughter as beneficiaries, equally per stirpes. In plain English, per stirpes means by the roots or down through the bloodlines. It means if a beneficiary dies, their share doesn't vanish, it drops down to their children. Tragically, Margaret's daughter passed away before she did. This meant that the daughter's share, 50% of everything, dropped down to her only child, Samantha. Samantha was 18 years old when Margaret passed on, a freshman in college. Now remember Margaret's fear? She didn't want an 18-year-old handling that kind of money. That's why she wrote that age 40 restriction in her will. But when Margaret died, the bank looked at the pay on death form, not the will. The form said, pay to the children equally per stirpes. The bank didn't care about the will. They didn't care about the trust clause. They didn't care about Samantha's maturity. They wanted to cut a check, $1.1 million cash, tax-free, and hand it to an 18-year-old. But now the uncle wanted to seize the money and hold it in trust according to the will. This is where I came in. I wasn't Margaret's attorney. I was actually the attorney for Samantha's father, David. When Margaret died, the family was in chaos. Uncle Robert, Margaret's son, made it very clear he wasn't going to help Samantha with college. He was taking his share and walking away. And he was going to hold Samantha's money back for decades and not pay anything because that's what the will said. So we were looking at Margaret's estate, hoping to find some clause, some reason to get support for Samantha in college. When I realized there were POD forms that overrode the will, it was a shock to everybody. Samantha didn't just get support. She didn't just get her education paid for. She got a fortune. And while that sounds lucky, it was also terrifying. An 18-year-old with $1 million is a target. It's a recipe for disaster. Margaret's attempt to keep it simple actually put her granddaughter in extreme financial jeopardy. But the irony doesn't stop there. Margaret also owned a house. Now, unlike the bank accounts, the life insurance, IRAs, and 401ks, the house didn't have a beneficiary form. This meant the house did fall under the will. And remember that clause in the will? Remember that clause? Hold in trust until age 40. Because the house was caught by the will, it was forced into a testamentary trust. This isn't a private trust. This is a trust supervised by the probate court. Because Samantha is only 18 and the trust lasts until she's 40, that house is now stuck in the court system for 22 years. That means 22 years of annual accountings, 22 years of filing fees, 22 years of asking a judge for permission to fix the roof or sell the property or getting forgiveness later. So Margaret failed twice. The cash she wanted protected was given away freely. The house she wanted to be simple became a bureaucratic nightmare. Now, I mentioned my client David. Margaret never really liked David. She didn't think he was sharp. But years before this happened, in fact, just a few months after his wife died, David came to my office. He didn't try to DIY it. He didn't rely on bank forms. We set up a revocable living trust. We retitled his house into the trust. We pointed his life insurance and retirement accounts to the trust. We put his bank accounts and other stock investments into the trust. His trust has the same rules Margaret wanted. Hold it for the kids to age 40, but because it's a living trust with the right provisions, it works. The trust would have let the trustee pay for Samantha's education expenses if anything happened to David. If David dies, the trustee steps in privately. No court, no probate. The insurance money goes into the trust, not to Samantha directly. The trustee manages it, pays for college, and distributes it responsibly over time. David, the guy Margaret doubted, secured his daughter's future perfectly if anything happens to him. Margaret, who thought she was smarter than the system, left a mess. The lesson here is simple. You cannot rely on a patchwork of forms to protect a complex life. Simple wills often lead to complex probates. Simple forms often lead to unintended windfalls. If you want to protect your family, really protect them, you need a plan that integrates everything into one bucket. That bucket is usually a revocable living trust. I've seen too many Margarets in my career. I want to see more Davids. If you want to be the hero of your family's story, don't guess. My book, Estate Planning Basics, breaks this down in even more detail, and you get access to the digital version free at freetrustcourse.com. Or if you live in North Carolina, visit my website at raleightrust.com to schedule a strategy session. I'm Jeffrey G. Marsacci, the Plain English attorney. Let's get your plan right now so your family doesn't have to clean up a mess later. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.